Good evening. My name is Alina Shoutsova. I am an immigration attorney from Brooklyn, New York, and I would like to have with you today's Legally Speaking seminar regarding new announced changes about 601A provisional waiver. Provisional waiver is a waiver that is a recent, relatively recent regulation that allows certain members of U.S. Residents, families, and today it's still United States citizens, to apply for a waiver of unlawful presence and wait for the results of the waiver in the United States. And today I would like to talk to you about changes that will be implemented by the end of this month, will be effective by the end of the month of August 2016, that will expand the way the waiver works. Basically, right now the waiver is available to only immediate relatives of the United States citizens. Now, USCIS announced that they expand the coverage of the waiver, and those who are spouses and parents of lawful permanent residents will be able to apply for the waiver as well. This is a big change because it will allow those who have not only family-based petitions but also employment-based petitions and diversity visa petitions that are ready and for which the immigrant visas are current. Those people will be able to apply for the waivers as well. So this one is a big change. The second big change that USCIS announced is that those with final orders of removal will qualify and be able to file for the waivers under certain circumstances. For the provisional waivers, those people will be able to file as well. The way it's going to work is that usually a person with a final order of removal, once the order is issued, becomes inadmissible into the United States for a certain amount of years based on the person's history in the United States. Usually it's 10 years. Let's say take simple situation, simple final order of removal, it's 10 years of inadmissibility if the person leaves the United States. Now, if the person files and gets approved Form I-212 or permission to apply for admission, if the person gets such a conditional approval of this form, of this waiver or permission, then the person will be able also to file for I-601A waiver. This is the very, this also opens a number of opportunities for people with final orders of removal, specifically for people who have orders of removal that were issued because they missed their hearings, didn't show up. And it's very important that if you have a final order of removal and now will be considering filing for I-601A waiver, you need to speak with a lawyer, because if the removal was based on something that may still create a problem for you, or if after the order of removal or deportation you were subjected to criminal prosecution, you should absolutely talk to a lawyer before you start doing anything, because I-601A waiver, just as before, can waive only grounds of unlawful presence and nothing else. So let's move on. So that's the second big change. Third big change, the USCIS eliminated deadlines, certain deadlines. For example, before the change, only people who did not have the immigrant visa interview scheduled prior to the implementation of the rules were eligible to apply for I-601A waiver. Now they eliminated this deadline, and now pretty much anybody and everybody can apply as long as they otherwise qualify. So this is a good change. Another good change is that USCIS eliminated reason to believe standard for the denial of the waiver. Basically what happened before is that the waiver would not be approved and would have been denied if USCIS believed that the person would be inadmissible on other grounds except for the unlawful presence grounds. Now the reason is eliminated because it was a little bit not clear, and there were a lot of denials that were not justifiable. So USCIS listened to Department of Homeland Security, listened to all those people who were complaining about this situation, and this obstacle was eliminated. It's a very good change. People who are currently in removal proceedings, they're still unfortunately ineligible to apply for the waiver, but they are eligible if the government agrees to administratively close their proceedings. And if their waivers get approved, then those people can file a motion to terminate their proceedings. And once that is approved, they will be able to travel out of the country using the waiver, getting the immigrant visa. So that's one of the options for those who are currently in removal proceedings and would like to use a provisional waiver option. Finally, a negative comment. Unfortunately, the new waivers did not change the application of the extreme hardship standard. So a person who would like to apply for the waiver still has to show that his or her relative, and now this relative, as I mentioned before, includes a lawful permanent resident, spouse, or parent, in addition to U.S. citizen immediate relatives. The person who is applying for the waiver still has to demonstrate that the person's departure will cause extreme hardship to the relative. And this standard of extreme hardship, there is a good and a bad in that there is no clear definition of what extreme hardship actually is. But of course, it makes applicants' job harder to prove because we don't have the clear standard that his relative is going to suffer extreme hardship. So as it was before, we will have to present a lot of different evidence showing that this particular case is qualified and this particular applicant met the extreme hardship standard. In addition to showing that applicant for the extreme hardship I-601A waiver, provisional waiver, also deserves government's discretion. Because don't forget, this application, like many applications before USCIS or Department of Homeland Security, warrant, in addition to statutory qualifications, an applicant has to show that he or she warrants discretion, basically good attitude on behalf of the government in their favor. So I hope this little video was helpful in understanding of the major changes that were announced recently by USCIS in connection with I-601A provisional waiver. And I will be publishing more information on my article on my website, so you will also be able to read about these changes and see if they will be helpful for in your situation. You can always visit my website for more information on existing I-601A waiver at www.shaltsova.com. Thank you.